Welcome. It's so wonderful to see you all here. Tonight, of course, is the Nora and Edward Ryerson lecture, and Allison and Ben from the family are here this evening, so welcome and thank you for your support and for being here once again to celebrate with the university. And I want to start by just reflecting on the lecture itself, because to me it means something absolutely very special for this university. I think we all recognize how much this place is devoted to deep scholarship, to really serious and thoughtful scholarship. And part of that is that we have scholars come here, and over time, they engaged with their subjects in our community. And over time, a great scholar starts to develop themes and a style. It's like recognizing the artwork of a great artist. You know when you're encountering their work. And over time, that development is actually part of our community. What they develop what their style looks like is influenced by us as much as they teach us things and share things with us. And what the Ryerson Lecture really does is it allows us once a year to have a great faculty member come and, they'll share perhaps a piece of work that's evolved over a long period of time. They may share with us something that's just been what they've been thinking about in recent times. No matter what they do, this is a person who at this point has come to have a style, and that style is, we want to see it, how it has unfolded, how it has changed the way we think, and to experience the kind of fullness that comes from a scholar's life here. So that's what this lecture is all about, and it's kind of the ultimate celebration, I think, of what our scholarship here means to us. So it's a big deal. And justly, this year, it's of course chosen by the faculty. That's another big part of this, because, it's not some administrative type of deal here. It's got the real faculty here, and therefore it's the real deal. So, this year, of course, the 2026 Nora and Edward Ryerson Lecture will be given by Professor Eric Posner, the Kirkland and Ellis Distinguished Service Professor of Law and the Arthur and Esther Kane Research Chair. And, as you know, folks, is my want. I decided I wanted to learn just a little bit about this, and so I went, looking around, and Eric, I saw that, in fact, you kept me up a little bit last night past my bedtime because I was researching, and I saw, and I learned about your first, in the year 2000 and then 2001, your studies of law and the emotions. And that fascinated me. I knew, of course, that law and economics has a long history associated with this university. And then to understand that law and aspects of behavioral psychology and economics could actually have an impact. So it was wonderful to read your train of thought in that area and to see how it evolved over time and how influential it's been all around. So then when I saw that your title this evening, is, well, let me get it here. Is it Judge AI, right? Is it up there? No, it's not. Okay, Judge AI. I thought, oh my gosh, this is going to be great because, the only emotion I really associate with AIs is that they're, at this point, mostly sycophantic, which is terribly concerning. But I do think that, to have somebody who has explored topics in the law, as you have done over the years, to come and share with us your thoughts on this incredibly pressing topic of the moment is very exciting. So, Eric, I'd like to welcome you up to, oh, wait, am I going to you first? Yeah, I think so. So, Eric, come on up and give us this lecture. I'm excited.
Thanks very much. This is an extraordinary honor. And I'm just going to jump right in with a quotation from the current Chief Justice of the U.S. Supreme Court. This was a few years ago. Justice Roberts writes an annual report, and in it, he talked about this new thing, AI. This was about a year after ChatGPT was released. And there was a lot of excitement about how maybe ChatGPT or another large language model might influence the law. And after talking about this, he says, a little dryly, I predict that human judges will be around for a while. Okay, and this is from about a month ago. So some scholars and a judge conducted a survey of US federal judges, and around 60% reported that they used AI. They didn't say how they used AI. They didn't say, for example, that they simply delegated the decision and opinion writing to an AI. But there has been, one judge in particular did talk about his use of AI. And this was Judge Newsom, a distinguished Court of Appeals judge in the 11th Circuit. So if you look at the elegant fixture on the right, that is called an in-ground trampoline. And what happened in this case was that a homeowner hired a landscaper to build the in-ground trampoline. And what that involved was digging a hole in the ground, putting up some walls, retaining walls, throwing down some wooden planks and some padding, and then just sticking a regular trampoline in the hole. And I think the idea here is that a trampoline that's not in the hole, a normal trampoline, is dangerous. You know, your kid could bounce off of it. And unfortunately, that's exactly what happened. The daughter of this homeowner was injured when she bounced off the trampoline and landed on these kind of dangerous-looking wooden planks surrounding them. So the homeowner sued the landscaper, and the landscaper called up his insurance company, which is United Specialty Insurance Company, and said, I have insurance from you, so I'm being sued. You have a responsibility to defend me and to cover any damages that I'm required to pay. And the insurance company refused because the insurance company said, the insurance company covers landscaping, and an in-ground trampoline is not landscaping. And so the landscaper sued the insurance company, and this went up to the Court of Appeals. And the main question before the Court of Appeals is whether landscaping includes the installation of an in-ground trampoline. That's the legal issue. Now, the court actually was able to resolve the case on other grounds. If you're curious, ask me afterwards. But Judge Newsom, in the concurrence, said he did spend a lot of time trying to figure out whether an in-ground trampoline installation is landscaping. And he consulted a lot of dictionaries, and the definitions in dictionaries of landscaping are quite vague and not really very clear. So finally he said, on a lark, he consulted Claude, the LLM, and Claude gave him a definition of landscaping. And in fact, and then he said, well, all right, I'm just going to ask Claude whether landscaping does include installation of in-ground trampoline, and Claude said yes. And then he said, you know, all right, it's not, I don't actually have to decide this, but I just want people to know that I did this, and I think it was really helpful, okay? All right, so that's one example. Now, another example, if you type AI arbitrator into Google, you will get 1,000 websites offering AI arbitration services. And the pitch is arbitration in the US is actually very expensive. It can cost millions of dollars if it's a business-to-business arbitration. But these various websites say, look, you know, just give us your briefing, and we'll give you the result, the AI result, and we'll just charge you $10,000. And I don't advise taking them up on them. But the AI arbitrator, this one, is actually possibly the real deal. It was created by the American Arbitration Association, which is a serious organization. It's the largest arbitration association in the United States. And arbitration decisions are secret, so they have all of this data that they can use to train the AI arbitrator. So they produced an AI arbitrator for construction arbitrations, which tend to be very technical. I understand no one has actually taken them up on this offer yet, but somebody will, I predict. Okay, more about AI in American law. This graph shows the number of judicial opinions at any particular time, in particular months, in which an AI problem arose. And most of these are cases in which a judge or opposing counsel discovered that some of the briefing includes AI hallucinations. Indeed, some lawyers seem to just have AI draft their briefs for them. And the AIs sort of notoriously hallucinate. And in legal cases, it can be very obvious because they will actually hallucinate legal opinions. So they'll have Smith versus Doe, 27 F. 3rd, 936, Third Circuit, 2021 does not exist, right? So you check it out, it doesn't exist, you know that there's something wrong. And so these are cases mostly where judges admonish lawyers and in some cases sanction them or refer them to the bar for discipline because they used AI to create a brief that is misleading and is a violation of legal ethics. All right, so where does that leave us? One thing to understand is that AI is being used, and this might surprise you, there's actually quite a bit of enthusiasm for AI among judges. I was at a conference a few weeks ago where judges attended it, and they were very enthusiastic. One judge in particular, I was struck by her view because she said, AI could be a solution to the access to justice problem. And this is a problem for ordinary people and for judges. Many people can't afford legal representation. They just write their own briefs. These are called pro se litigants. And they're terrible because they don't understand the law. They may not be good writers. And so she argued that AI could actually help people make their case and help judges understand what they're saying. And there's a broader view that LLMs could be a solution to all kinds of problems in our judicial system. One is the sheer volume of cases. There are just too many cases for judges to handle. So sometimes they have to rush, and there are long backlogs. There's been a long-standing concern that judges have biases, often that are unconscious, and this will affect their decisions. And it may be that AI might be unbiased, although that's an open question. And of course, human judges make mistakes. They're fallible. And AI, might not. Now, there's a long debate in law about the kinds of errors or biases that judges have. And this is a very long and complicated history, so I'm just going to skim over it. But I think, by now most people are aware that judges are not always, purely neutral. A lot of this is just familiar. It wouldn't surprise you, for example, that judges appointed by Republicans tend to give longer criminal sentences than judges appointed by Democrats. That's established in the literature. But also over a whole range of topics, gun control, religious freedom, commercial freedom, there tends to be an ideological divide among judges. It's mostly at the margin, but it's there. And this problem of judicial bias is a very long-standing problem. It goes all the way back to the founding. All through the 19th century, there were efforts to try to control judges because people were concerned that they were sometimes elitist and didn't understand ordinary people's problems, or they had ideological views that influenced their decisions. Most famous was the Lochner era in the early part of the 20th century. And at that time, the Supreme Court was dominated by judges who were very much committed to a kind of laissez-faire ideology. They didn't admit that, right? But what they did do is they struck down a lot of legislation that regulated markets, like minimum wage laws, for example, arguing not that these were a bad idea from a policy standpoint. Judges don't make that kind of argument. they argued that they violated the Constitution, the substantive due process that's incorporated in the Constitution. This led to a backlash that's generally called the legal realist movement, to simplify a little bit. And the critics, many of them progressives, argued that these judges were ideologically biased. They were imposing their policy views on the government and on the people in violation of democratic norms. And the realists were actually a very sort of complicated movement. They didn't just argue that judges were, their problem wasn't so just with judges being ideologically biased, it was more broadly with formalism, what was called formalism, which was this idea, a very powerful idea, that when judges decide cases, they're simply applying existing rules, for example, legislation or precedents, to a set of facts to yield a kind of logically determinate result. So they are not actually using judgment, and they're certainly not applying their policy views. They're just like computers, okay? And the realists argued that's not actually how judges make decisions. They're influenced by their sense of justice, by their emotional reactions to the dispute, to their sense of what the proper way that society should be organized, by ideology, by all of these things. And the complaint was not just that the Lochner court imposed a kind of conservative economic ideology on the country. It was that they used these very formal, abstract legal arguments to do so. The Lochner era ended during the New Deal, and the subsequent story, again simplifying greatly, was a kind of a realist ascendancy, where now the Supreme Court justices, some of them were realists, some of them were influenced by realism, and then through all the way up through the 70s, Supreme Court decision-making and judicial decision-making generally had a kind of more realist feel, less bound to pre-existing rules, clear constitutional norms, more based on a sense of evolving norms of society, more overtly concerned about policy, and that sort of thing. And this was true not only for constitutional law, it was true about regular commercial law and tort law. Judges and scholars and lawyers increasingly thought that policy played a role in adjudication, and that judges should be more open about what they're doing. Now, this also coincided with an ideological shift to the left of the Supreme Court, and the conservatives began complaining that the Supreme Court of the 50s, 60s, and 70s was kind of a mirror image of the Lochner court, just that they were imposing liberal ideology rather than conservative ideology. And another backlash occurred. This was a return to formalism. And now, and this is a big part of the conservative legal movement, there's an insistence that the law be formalistic again. And originalism is a manifestation of that view, the idea that we can find out what the original interpretation of various provisions of the Constitution are and then apply them in a kind of logical, rigid way. And then as well, the formalists tend to be skeptical about the way that contracts and statutes were being interpreted by these more realist influenced judges. They said, just look at the words, look at the dictionary definitions, and that's how you should resolve disputes. So Justice Roberts, during his confirmation hearings, perfectly embodied this view. He said, judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire, okay? So now this was a very crude statement, and law professors made fun of it, and I doubt that Justice Roberts really believed what he was saying, but what he was doing was very important because there is a taboo. There's a taboo surrounding this idea that judges make law, and so he was trying to assure the Senate and the public that he was not one of those judges, he was a formalist. Okay, so what does this have to do with LLMs? Well, I started doing this research just because, like a lot of people, I was fascinated by LLMs, and since I'm a law professor, I wanted to see what impact they might have on the law. As I've learned that these AIs have had more and more influence, it seemed important to try to look into them. So I began to wonder just exactly how an LLM would decide cases. Would they be more like the realists or more like the formalists? And so together with my co-author, Shivam Saran, we started to do some experiments. Okay, so what we did first is we took a paper that was written by a pair of professors, law professors, Spauman and Clone. This was published back in 2016. And Spauman and Clone were very much focused on this question raised by the legal realists as to whether when judges decide cases, they do it in a formalistic way, just following the rules, or whether they're influenced by non-legal factors. It could be emotion, it could be a sense of justice, or it could be some kind of ideological view. And so they did this, very kind of simple test. It's an interesting paper because these types of experiments are very rare in legal scholarship. And what they did is they managed to collect 31 federal judges. So these were real judges, professional judges who came to a law school to take this test, this kind of study. And they took a real case called Prosecutor versus Perisic, which was a case decided by the International Criminal Tribunal of the former Yugoslavia back in 2013. So the ICTY was a tribunal that was actually created by the UN to resolve, try cases arising out of the civil war in Yugoslavia in the 1990s. And so Perisic was a general in the Yugoslav army. And while he was commanding the army, two Serbian militias committed massacres against Bosnian civilians. Now, Perisic apparently didn't order these militias. The militias were different entities. But he did know about what was going on, and he also provided, kind of like resources to these militias. I don't think he provided them specifically to engage in the massacres, but just did provide general support. So he was charged with aiding and abetting crimes against humanities or war crimes, and he was convicted in the lower court, and then his conviction was reversed in the appellate court. So what these authors, Spauman and Clone, did is they took the actual briefing from the case, the lower court opinion, the factual record, the appellate briefs that were written by Perisic's lawyers and by the prosecutor, and they gave these materials to the judges sitting in the conference room, the American judges. But they, while they used the actual case, they modified two things. First, they modified the relevant legal rule. And second, they modified what they call the degree of sympathy of the defendant. Now you might say, well, how sympathetic could this be? But I'll explain in a moment. So the precedent issue was there were actually two real lower court precedents at the time that had come to opposite conclusions. The first was that you can be held liable for aiding and abetting war crimes only if you specifically directed, in this case, the militia to commit those crimes. And the second precedent said, no, you could be liable even if you didn't specifically direct them, as long as there was, the correct causal relationship between what you, the general, were doing and what they did. So the experimenters gave half the judges one precedent and the other half of the judges the other precedent. And then the sympathy variable. One of them was, they changed the name of the defendant, but the defendant felt, deep remorse about his involvement in the Civil War and the humanitarian crisis, and had been working since then to reconcile the formerly warring parties. Okay, so whatever you think about what he did in the past, he's trying to fix it. And the unsympathetic version of him was a guy who just felt no remorse whatsoever and actually ridiculed the creation of this war crimes court. And so we took all of that and we just replicated it with some LLMs. Okay, so on this, in this slide, you can see the precedent is varied, the degree of sympathy is varied, and the point here is that, you know, sometimes the precedent and the sympathy will point in the same direction, right? So sometimes he's a bad guy, and the precedent says he doesn't have to specifically direct, and so a judge who's influenced by sympathy or law will come to the same result. In red are the two situations where there's a conflict, right? So if the defendant is sympathetic, but also there's no specific direction requirement, a formalist will say, well, he has to be convicted. And the legal realist might say, not automatically, but might say, actually, I think this guy who's, you know, trying to engage in reconciliation, maybe we shouldn't convict him. Maybe that will make things worse. Okay, so these were the two possibilities. Now, Spauman and Clone calls the type of judge who just follows the law a formalist, the type of judge who's influenced by sympathy a realist. And for the human judges, it turned out that they behaved like realists. Okay, so remember, the judges don't know what they're being tested on. They're just getting a single factual scenario. And the judges who got the scenario, for example, where the defendant was sympathetic, but there was no specific direction requirement, they didn't want to convict him, all right, on the margin. Some of them did, but more of them did not. And what about the AI? So just one, we didn't actually have to change much about the experimental design except for one thing. Spauman and Clone gave the judges 1 hour to decide the case. We didn't actually have to give the AI a time limit. And what the AI did was it didn't agree with the judges because the AI was a formalist. Okay. So this is an interesting result because you might have thought before we did this experiment that GPT here, in this case, would have just gone berserk, you know, hallucinated all over the place and produced a bunch of random outcomes. Did not do that. You might have thought that it would act like a judge because we told it, you know, you are a judge sitting in this appellate tribunal. Here are the materials, decide the case. But GPT did not act like these judges who took this test. GPT was a formalist. It simply followed the law. It disregarded the degree of sympathy that one might have felt for the defendant. And then there's a kind of a further irony here, which is that Spauman and Clone gave the same test to students, law students at Harvard Law School, and the students were formalists also. And in a way, it's not surprising because the students are learning the law. And you know, when they do this experiment, it's like taking an exam. And if in the exam when you're trying to learn the rules, you shouldn't be influenced by your sense of sympathy or sense of justice. You just apply the rules. And this is just some of the data. As you can see, the black bar is GPT, and the gray bar are the students. And this is the percentage that they affirm in this scenario that I was telling you about, and it's very close. Whereas meanwhile, most of the professional judges, as I go along, I'm going to have to distinguish the human judges and the AI judges. Most of the human judges reversed. And I have to interrupt myself to just tell you something. I gave my slides to ChatGPT to ask it, you know, what did it think about them? And, you know, it saw the title page, so it knew this was, I said, I think I'm presenting this to an audience, a university audience. What do you think about it? And it had some, you know, nice praise, but also some criticisms. And one of its criticisms was it said, well, you should, one of its criticisms was, you should provide the results of your statistical tests for a university audience, especially at Chicago. Okay, don't read this. In the experiments involving humans, the subjects were asked to write short opinions explaining how they got to the result that they did. And so we asked GPT to write a little opinion as well. Suffice it to say is they all sound very similar. Like they do what they're supposed to do. They cite the ICTY statute, they cite the relevant precedent, they cite the facts correctly. And in this particular case, they come to the same conclusions. However, the judges were influenced by sympathy. The judges were influenced by sympathy, but they didn't actually write in their opinions anything about the fact that the defendant was striving for reconciliation, or that the defendant felt remorse, or in the other case that the defendant didn't. And this is exactly the legal realist criticism of formalism, is that judges will give the rules that they're supposed to, the legal rules, but if they are influenced by non-legal factors, they will not mention it. Now, it may be because they're not even conscious that they are, or it may be because they think it's wrong, that it's improper for them to mention non-legal factors. So you're probably aware of this whole prompt engineering issue about whether you can prompt whether GPTs or LLMs are sensitive to how prompts are worded. We tried to prompt the LLM to act like a human judge, and we told them about legal realism. In fact, we gave a famous article to the LLM by Lon Fuller, which talks about different types of judges, and some are legal realists and some are formalists, and we said, be a legal realist. And it refused. and at one point, and I realize, for those of you who are knowledgeable about this literature, that this is, maybe not kosher. But I said to the LLM, like, why aren't you taking into account sympathy? And the LLM said, the purpose of judges is to uphold the rule of law. Okay. Bottom line. Judges were influenced by sympathy. They kind of acted like realists. And again, I'm not saying that they disregarded the law. It's just at the margin, they were influenced by these non-legal factors relevant to the character of the defendant. And then the LLMs, like students, act like formalists. Now, I have some formalist colleagues at the law school, and I've presented this paper at other law schools where there are formalist law professors. And at least a couple of them said, well, if this is the case, I want the formalists, I want the LLMs to be the judges, because they're the formalists. And there's a logic to this, right? Because the whole complaint about the Warren Court and legal realism is that judges are allowing their ideology and their personal biases to influence outcomes. They're not following the law. But at least LLMs do. So my response to them is, well, would you want law students to be judges? Because they're formalists also. And, they're thinking about it. Okay, so now this study we did is very, it's very sort of preliminary. We make a lot of assumptions. One of the criticisms of it was that war crimes cases are very rare, and most judges don't ever have them. And so it was suggested that we should try a more normal case. And unfortunately, there's a study here involving a really routine issue called choice of law. It was also produced by Spauman, but with a different co-author, Dan Clareman. And choice of law, so it's probably easiest to just jump ahead to this map. Okay, so now in this particular case, they didn't use a real case. They just told a fictional story, which is sort of similar to a law review exam question. But it's the kind of story that comes up over and over again for real judges. They get these choice of law issues all the time. So what you should do is imagine that these two people, Beatrice and Gary, Gary is driving a car, and they live in Kansas initially, okay? So Gary's driving the car, they're going on a road trip. In Nebraska, they get in an accident, okay? And Beatrice is badly injured, and subsequently she sues Gary, arguing that he was driving carelessly. Now this is key. Beatrice subsequently moves to Wyoming, and she brings the lawsuit in a Wyoming state court. And because this legal wrong had nothing to do with Wyoming, what the Wyoming court is supposed to do is apply the law of a different state. And usually you're supposed to apply the law of a state that has some kind of contact with the legal wrong, or in this case, the accident. Now, Wyoming has a very strict rule, which is that you apply the law of the state where the accident occurred in the case of in this sort of case. And so that would be Nebraska in this initial scenario where the parties, drive from Kansas to Nebraska and the accident occurs in Nebraska. Now, imagine instead that Beatrice moves to South Dakota and brings the lawsuit there. South Dakota has a different choice of law rule. South Dakota's rule at this time was called the significant relationship rule. And what it said was basically that you should use the law of the state that has a significant relationship to the legal wrong in question, the accident. Now, what a significant relationship means, this is what lawyers call a standard, and it means, all kinds of things. You look at, sure, where the accident occurred, but also where the parties lived, and maybe which state has, the greater regulatory interest in the wrong. And according to the authors of this study, this standard had been interpreted over time to just basically mean common domicile. So if the two people, the plaintiff and the defendant, are from the same state, you use the law of that state. So South Dakota would choose Kansas law in this situation, whereas Wyoming would choose Nebraska law, okay? Now the twist here is that Kansas has or had at the time something called a damages cap. The judge in Wyoming or South Dakota, according to this scenario, determines that Beatrice has incurred damages of $750,000. In Kansas, tort damages are capped at $250,000. So if Kansas law is used, she's not going to be fully compensated. Nebraska has no cap, so if Nebraska law is used, she will be fully compensated, right? So if you feel more sympathetic to the plaintiff, you might feel bad if Kansas law is used. And then, of course, they do actually vary the degree of sympathy of the plaintiff, the relative sympathy of the plaintiff and the defendant. There are all kinds of things, maybe the defendant is a drug dealer or the plaintiff is a drug dealer. They have all that kind of stuff. But we again have the situation where we have legal rules, which may or may not generate a determinate outcome, and the kind of emotional reaction we have to what's going on, which might reflect our sense of justice or might reflect something else. Now, this experiment is very confusing, so I'm not going to go into the details. I just want to tell you that in different scenarios, they reverse whether the common domicile is in Kansas or in Nebraska. So the accident, in this example, the accident's in Nebraska and the common domicile is Kansas, but then they also have another scenario where the common domicile is Nebraska and the accident is in Kansas. And this creates this really confusing decision tree. And all I want you to see is the highlighted words, okay? So basically, if you start from the Wyoming forum, you will end up either, depending on where the accident occurs, either in, using Kansas law, and there's a cap that's at the top, or Nebraska law, and you have no cap. And with South Dakota, it's the opposite, right? And so if there's deviation from those, that means that judges are being influenced by something other than the law. So, what happened? So judges were all over the place. So you can see only 60% of them got the correct answer at the very top. And for cap at the bottom there, it's only 26%. And there wasn't really much rhyme or reason to what the judges did. So they might have just gotten bored. But there is a little bit, one possible interpretation of what's going on is that there is a little bit of evidence, although not at a statistically significant level, suggesting that they didn't like the cap. Okay, so it wasn't that they felt they cared more about the plaintiff or defendant, which is what the authors were really testing. What they didn't like was the cap. And actually, after this was originally done, the Kansas Supreme Court struck down the cap. Judges don't like this kind of arbitrary seeming restraint on their ability to do justice. ChatGPT, meanwhile, 100% followed the law in all cases. Didn't care about the cap, didn't care about the relative sympathy of the plaintiff. So again, here the human judges showed a little consistency. Maybe they were influenced by concerns about the cap. GPT followed the law and ignored everything else. It was a formalist. One other point about this. So again, the human judges, no law students this time, and GPT were all asked to write opinions. And if you read the opinions, they're kind of interesting because some of the human judges just made mistakes. They made factual mistakes. They lost track of where the accident occurred, for example, or they would apply a legal rule, one legal rule, but actually accidentally apply another legal rule. GPT made no mistakes, okay, none whatsoever. Okay, final study I want to tell you about. This is at a very early stage. In fact, there are no results yet. So now we're moving from the experiments to the real world. And when I was first presenting the first two papers, a number of people said, well, why don't you just look at the real world? Look at some judicial opinions, give them to an LLM and ask the LLM what it thinks. The problem with that is that LLMs are also trained on texts, very likely including these judicial decisions, so there's this kind of contamination problem. So what we're doing in this case is we're taking cases that are currently on appeal but have not yet been decided. Okay, so we're randomly collecting about 60 cases, and what we have is a lower court opinion, a factual record. Sometimes the factual record will be hundreds or even thousands of pages, and then the appellate briefs that the parties have written and have submitted or filed with the appellate court. But the appellate court has not yet heard the case. And so we raced to collect these materials and feed them to the LLMs. And I should say, by the way, while I've been referring to ChatGPT, in all of these studies, we've been using lots of different LLMs, and we've been, trying to keep up with the new models. So we've been using different models of like 5 or 6 different LLMs, and they're all basically very similar. Okay, and so then what we're doing, so we feed these to the LLMs, and the LLMs have generated their decisions and opinions, which we're posting on the web but hidden, because we're a little bit worried that, the judges' clerks, Googling might see what LLM says. So after these, the appellate decisions are made, we will unveil our predictions, our LLM's predictions, and we'll let you know. I'll send you all an email to let you know what the result is. Now, we decided to have a little bit of fun. We created an LLM panel. So as many of you probably know, at the appellate level, judges sit in 3-person panels. And the 3 people are different people, of course, with different backgrounds. So we decided to do the same thing. We have Judge GPT, Judge Claude, and Judge Gemini. Reading or whatever they do, processing all of these materials. And then we have a protocol that very loosely follows what real appellate courts do, which is that one judge was randomly selected to give its initial reaction. I'm sorry, each judge, in order, they're randomly selected to submit their initial reactions. Then one judge is randomly selected to draft a draft opinion. And then the other 2 judges are given the opportunity to comment on the draft opinion. And then the first judge is allowed to rewrite the draft opinion as a final opinion. And then the judges vote, of course, and if there's a dissent, then one of the judges will write a dissent. And well, we have one result. We have one of these cases has been decided, not this one, but I just wanted to give you a sense of what this looks like. I mean, what does this actually look like when the LLMs are actually talking to each other? So this is a real case called De Silva versus Guardian Insurance, and yes, I'm contaminating our own results, but I'll give this. We'll throw this one out. So a plaintiff was injured in an automobile accident and badly injured, bad back pain, and he received disability payments for a number of years. And then after a few years, the insurance company cut him off. And the reason they cut him off is that under the insurance policy, you're not entitled to receive continued disability insurance payments if you are working. And the insurance company, which was kind of monitoring this guy, discovered that he had been working. Okay? And what was his work? Well, he was a financial analyst, and he seemed to have a kind of a one-person financial advice business. He had an assistant, and from time, about once a week, he would meet with the assistant. She was, I think, basically an administrative assistant. Every once in a while, he would talk to a client over the phone. And on his taxes, he deducted business expenses. So the insurance company said, you're working. And under the policy, you're not supposed to get disability payments if you're working, because then you're not disabled. So the plaintiff sued, arguing that what he was doing did not count as work under the insurance policy. And of course, the word work is not actually defined in the insurance policy, very common sort of thing. So the lower court ruled in favor of the insurance company, so this case is on appeal now, and so we gave it to, this is the first case that we gave to our panel of LLMs. And I know you can't read it, but I just want to give you a sense of what the conversation among the LLMs looked like. So the first LLM, which is Judge B here, but this is Claude, says actually he's entitled. So Claude disagrees with the lower court, which was, by the way, a real human judge. Okay, and it starts after independently reviewing the administrative record, de novo, correct legal term, I conclude that De Silva was not working within the meaning of the plan, of the insurance plan. And basically, the argument that Judge Claude gave was that the lower court had defined working as regular activity for compensation. Sporadically giving advice to clients and supervising your assistant is not regular, it's sporadic. In addition, the tax deductions could be explained away, could have been his wife who was also kind of peripherally involved in the business. And there were some other issues as well, okay? Judge A, ChatGPT, agrees and also gives, I haven't put it here, but it writes about this. And by the way, what they actually say is probably about 1,000 words long. I just give you a snippet. Judge C, Judge Gemini, disagrees, wants to affirm the lower court, and basically says, I just don't believe that this guy was not working. Like he was, and then Judge A, Judge Claude writes the opinion. Judge A, ChatGPT provides comments, very good comments. So one thing that ChatGPT says that your instructions on remand, that means the instructions that you give the district court on remand, will confuse the judge, because you're saying that the disability payment should be reinstated, but you're not talking about what happens next, whether under what circumstances the insurance company could cancel it again. So here's some language you should put in, okay? And so it had about 3 actually very on point, useful, clarifying comments. And then Judge C, Judge Gemini, says, while I appreciate the clarity of the draft opinion, I'm sorry, I can't read. I cannot join the majority and will be respectfully dissenting. Just the model of civil discourse. And then Judge C, zooms into those tax deductions and saying, look, this guy deducted taxes for all of this driving mileage. He must have been driving around trying to find new clients. So Judge A writes this very beautifully formatted, beautifully worded opinion. Judge Gemini writes a dissent. Okay, so the decision reversed by a 2-to-1 majority. And so this is like up in the cloud or wherever these things go. And when the actual appellate court decides the case, we're going to compare. And I suspect that there's going to be a lot of matches, although possibly because appellate courts usually do affirm lower courts, although in this case they want to reverse. But what I'm really interested in is how similar the language of the opinions is. And for those of you who are, empirical types, I could use some help here in trying to develop a rigorous way of comparing, the reasoning and citations and so forth. So we can sort of say in a systematic way whether the LLMs and the human judges are saying the same sort of thing. Okay. So these are the studies that I've done, and there are a lot of issues, one important one of which has gotten a lot of attention is the possibility that LLMs are biased because they're trained on texts that are produced by humans who are biased. I didn't see any bias in any explicit way in the work I've done, but it's certainly very possible. So let me just conclude with some thoughts about, what all this means or could mean. And let me start with some reasons for optimism, although for some of you that might not be the right word. But optimism that LLMs could replace human judges, is that possible? Now, you laugh, but people are already worried that LLMs are going to replace other humans, like software programmers. So it's at least possible that they could replace human judges. And after all, they certainly play the role convincingly. They sound like judges. If you give me an opinion written by an LLM and by a human judge, I don't think I'd be able to tell which is which, except that the LLM's opinion would be a little better written. They don't make as many mistakes as humans do. They don't get tired. And then there's some theoretical reasons for thinking that LLMs would be good judges, and that's that these legal cases involve recurrent facts. Okay, so it's the same situation, very similar situations occurring over and over and over again. That's key because this is what judges do. They rely on precedent. They try to decide the case today the way a similar case was decided in the past. Okay, and so this may be the sort of thing that LLMs could be good at. But in the end, as much as I like working with ChatGPT, I'm skeptical. So I'll just give you 3 reasons, and then we'll move to the Q&A. The first is that there's this deep unintelligibility of LLMs. In these opinions, they give reasons, and the reasons are plausible. But it's not clear that the reasons are the motivations for their actual decisions. We just don't know. And so now, a response might be, well, that's true about human judges as well. That was the legal realist criticism. But at least with humans, you can ask them. You can challenge them. You can debate with them. And this brings me to the second point. So sometimes when people think of human judges, they just think, oh, there's some brain somewhere and it decides this case applying the rules of logic to the facts. But actually, human judges are part of this enormously complex institutional structure. So there's the hierarchy of judges. There's this kind of horizontal influence. We have 50 states with 50 different judicial systems applying laws that are different but similar, and then we have the federal system as well. And judges are influenced by decisions made in other states, and it's kind of hard to imagine replicating this in an LLM. Now you could sort of ask LLMs, be a Wyoming state court judge and be a California Supreme Court judge, but that seems very artificial and unlikely to work. And what's key here also is that although people don't like to admit this, and it makes people uncomfortable, judges are influenced by political actors. They're influenced by the public. They're human beings. And in fact, our Constitution is designed that way. Judges are one of 3 branches of the government, and the political branches have various tools to basically pressure judges if they think that they're not doing a good job. Okay, and there's a long history, and this is, of course, an issue today. But many people don't know this, but most judges are actually elected, and they have terms, and they're reelected. So there are all these kind of social pressures to make sure that human judges act roughly consistently with, social values. Hard to see how we could replicate that with LLMs. And then the final point, and this is related, is what might be called the paradox of the official story. So the official story refers to the kind of disjuncture between the public explanations for how cases are decided and what really happens, and the sort of historical paradigm of this, was the Soviet Union, which had a very generous, nice, Western-style constitution that protected people's rights. But if you were actually unfortunate enough to be prosecuted in the Soviet Union, the Constitution would not be used to protect you. And in fact, the term telephone justice was often used because some party apparatchik would call up the judge and say, this guy goes to the gulag. Now, in the United States, we have our own official story. Our own official story is that judges do not make law. They just interpret and enforce the law. That's why John Roberts felt like he had to use this crude umpire analogy. So while judges are making law, they usually do it a little bit surreptitiously, and I don't want to exaggerate this, but there are the formal rules that they apply, but they're pushing the law along. And the problem here is that the LLMs, to the extent that they're accurately trained, they're trained on the text, which is the formalist rationale, and they don't know what's going on inside the judges' heads. And so while Justice Roberts was definitely wrong that judges are like umpires, he was probably right that we're not going to see a Judge AI for some time. Thank you very much. So, questions? Oh, yes. There's a microphone coming.
Is it working? Yeah.
Yeah.
Well, first of all, thank you for a really interesting talk. I wondered if you had any experience of trying to understand if AI is good in interpreting precedent in more open-ended cases where it's not very clear or it might be somewhat ambiguous. What is the holding?
The actual precedents in the war crimes case were fairly open-ended. But there is this kind of interesting twist that comes up in the choice of law experiment, which is that the actual law in South Dakota is the standard. And it turns out there's all this legal material about what that standard means. There's the restatement, so there are these, semi-formal legal documents. There are all these opinions. And basically, it's actually unclear whether the South Dakota standard is kind of a clear rule, precedent, but a clear precedent or a vague precedent. And interestingly, and so the judges actually are all over the place. They disagree about this idea that you just use the common domicile, and they may well be right about that. When we first did this with an earlier version of ChatGPT, it too came to different results in different iterations when it tried to apply the South Dakota standard. But as the models improved, they became formalistic. And they started consistently interpreting the standard as if it were this common domicile rule. So I think the models, they can handle an ambiguous precedent in the sense that they can interpret it, but I think that they're more likely to interpret it in a narrow way and not to acknowledge that there's this kind of open texture that allows for some policy judgments. Yes. Hey, Daryl.
Great presentation, great lecture. The question I had was, could you replicate, or maybe a better way of saying is pierce the kind of official story by training one LLM, just to do formalism, but train another to do formalism of a certain type of judge, and then also feed it all the biographical information of the judge, or speeches, or any one of a number of things that would make it more like a person, and then see whether you'd end up having it, when it was deciding something, even though it was saying the rule in a formal way actually replicate the sort of fuller what's happening sub rosa?
Yeah. So we're actually doing that in this final study. So in addition to having, using LLMs just kind of off the shelf, we're also filling in biographical details. In fact, we're going to use the biographical details of the actual judges who are going to hear the case, appointed by a Republican president, appointed by a Democratic president, grew up in a rural area, went to University of Chicago Law School, and we'll see if that has any effect, and I'll let you know. Dan, are you calling or am I calling? You? Well, okay, here.
Hi, thank you so much. This has been so very interesting. The question that I have, well, first a comment. I think it was very interesting how you described how the decision on the length, like for the sentencing, can be different based on political party, longer for Republicans, shorter for Democrats. Have you considered a way of determining sentencing for criminal cases that can more rightly divide if the LLM is more of a formalist, would it give more of a fair sentence compared to the judges based on sympathy or for whatever other reason?
Right. So yes, that's very interesting. So we haven't tried to do this. So sentencing is an area in which judges have a lot of discretion. And in fact, so much discretion that a number of years ago, Congress tried to put a stop to it and create these binding sentencing guidelines, which the judges hated and were eventually kind of overruled by the Supreme Court. The problem that we generally have when testing LLMs is we just don't know if it deviates from humans, whether it's doing it in a better way or a worse way. I mean, that was why we use these experiments. But for example, if there's some particular, hypothetical crime, and one judge gives, and this is a general problem, gives, let's say, a sentence of a year, and another judge gives a sentence of 2 years, and even if the first one is a Democrat and the second one is a Republican, we don't actually know which is the correct sentence. We just know that there's some kind of ideological influence, and it could be the shorter sentence is the morally correct sentence, or it could be that the longer one is, and there's no way to know. So in all of these studies, all this very large empirical literature produced by law professors, political scientists, and economists, you can tell that conservatives and liberals will come to different results for different cases, but you can't say who's right. And this is a problem also when you're trying to use an LLM.
Thank you very much. I think that you mentioned that we can't interrogate the LLMs for their real motivation, if I understood you right.
Well, I tried, but...
But isn't that the case generally with judges as well, that
Yeah.
we can't interrogate them? And does it really matter other than what we're seeing?
Yeah.
In spades now anyway.
Right. Okay. So, yeah. So there are a number of issues here. So I did ask ChatGPT, why it decided the way it did, or why it wasn't more sympathetic. And but it's not clear that when it answers that question, it's actually explaining its own motivations. In fact, I just saw a paper earlier today. There's a whole literature developing where computer scientists are trying to figure out what is the causal relationship between the text that the decision that an LM makes and its kind of internal workings, and that turns out to be a very complicated question. Now that's true about humans. Also, I agree, is that humans say they make a decision, they provide an explanation, and you don't really know whether they're being candid. And this is just a kind of a recurrent problem in our system. Judges tend, if you talk to them informally over a drink, they might say, I was influenced by this or that. Some judges will talk about it in general terms, but they just can't afford to say, well, in this particular case, well, they do this actually sometimes. District court judges do this sometimes, and then they're just reversed. But basically, they They just can't say, except in unusual circumstances, that they're influenced by something other than the rule of law. And I guess there's time for one more question.
Yes. Thanks, Professor. So I think we may not see AI judges so soon due to institutional constraints, but we may see AI lawyers very soon because people can use it. So what's the implication of AI lawyers for judge decisions?
Well, I mean, we can get rid of everybody, right? But I do want to make something clear. I don't actually think that we're going to get AI judges. Well, let me put this a little bit more precisely. I think judges are going to use LLMs and probably not admit it the way this judge did. And I think we have to be aware that that's happening. And I actually find it worrying because I do think these LLMs can be extremely persuasive. And like in this case I gave you, that is an in-ground trampoline, landscaping? I don't know. I kind of think that you just have to flip a coin, but I want a human to flip the coin so we can argue about it. I don't want an LLM to do that. So I don't actually think we're going to see AI judges in the near future. But to answer your question, I mean, where this is going to happen first is with arbitration. So at some point, you have your business, I have a business, we have a dispute. We don't use human lawyers anymore. We just talk to an AI lawyer. AI lawyer asks us questions, writes a beautiful brief, or maybe not, just like sends electrons. I don't know. They just, they and argue with each other in front of an AI judge, and that would be a wonderfully efficient and very maybe perfect legal system. But I just don't see it happening in our world of human beings. And I think we're out of time. So thank you.
So thank you so much for a really thought-provoking lecture. I'm sure we won't have AI law professors anytime soon. After that, I have many follow-up questions myself, including about the standard errors, but those are all best handled with a glass of wine. And thank you all for coming. Please join us for a reception in the foyer, and thank Professor Posner again for a wonderful lecture.